All right. Welcome everyone to this presentation on the importance of impartial courts. We will continue to admit attendees, but let's get the program started. I'm your moderator, Dorothy Skye, President of the League of Women Voters of Wisconsin. I'd like to begin by framing the discussion. Though everyone suspects we may be an overly litigious society, we rely on our courts to be final arbiters in many instances and to render fair and impartial judgments after hearing any case. We assume that the same evidence heard in one court based on the law and constitution will yield the same decision as that heard by any other court, and accordingly will result in the same sentencing. Today, however, our courts do not always conform to these basic expectations. Justice is not always blind, but is susceptible to the influence of partisanship and money. Judges who should recuse themselves do not always do so. Savvy, plentifully lawyered corporations can shop for favorable judges as more intermediary and business courts emerge in our state and around the nation. Here's our agenda. We'll begin a discussion in Wisconsin about the importance of an impartial judiciary with three panelists who will share their perspectives on the issue and set the stage for future discussions. Let me introduce these well-qualified speakers. Doug Poland is a partner at the Stafford Rosenbaum firm in Madison. He's also a co-founder of Law Forward, a nonpartisan, nonprofit law firm focused on preserving representative democracy in Wisconsin. Doug served as lead trial counsel for plaintiffs who successfully challenged the Wisconsin Assembly legislation districts before three judge federal panels in 2012 and 2016. He was a lead trial counsel for the city of Kenosha in a redistricting challenge against Kenosha County. And he was a member of the legal team that represented the respondents before the US Supreme Court in the Gill v. Whitford partisan gerrymandering case. Douglas Keith is counsel in the Brennan Center's democracy program, where he works primarily to promote fair, diverse, and impartial courts. Previously, he was a fellow at the Brennan Center working on matters related to money and politics, voting rights, and redistricting. Keith's work has been featured in numerous prominent news media. Keith also previously worked as a Ford Foundation Public Interest Law Fellow and has had several roles as a voting and elections advocate. Keith is a graduate of NYU School of Law and Duke University. Debra Cronmiller is the executive director of the League of Women Voters of Wisconsin. Debra served in state government in the Department of Workforce Development and the Department of Children and Families. She started her career in nonprofit management, assisting adults with disabilities and homeless individuals. She has served as director of the Fox Cities Workforce Development Board and is currently a director on the Community Shares of Wisconsin board. She's on the steering committee for the UW Civic Health Initiative and is also a member of the Fair Maps Coalition and is state redistricting champion for the people-powered Fair Maps Initiative. Debra is a graduate of UW-Madison. All right. Doug Poland, you can screen share and unmute. Our first speaker is Doug Poland, who will share a bit of history about what has happened with redistricting cases and other voting rights cases in the courts. In doing so, he will make it clear why fair courts are critically important. Doug, the virtual podium is yours.
Thank you, Dorothy. I'm going to share my screen here with everyone. And thanks very much for having me tonight. I appreciate it. Just to reiterate something that point that Dorothy made, the importance of courts. I feel as a lawyer, one of the main things that we do is we provide advocacy, courts provide a forum for people to work out their disputes in a productive way. And as litigious as a society as we might be, the courts are there so that we're not solving our problems violently. Hopefully, we're doing it in a way that that there's a process and that it's supervised, and we have the assistance of judges and other court personnel to help us along the way too. So I really do view the role of courts and of lawyers as being one that that really allows us to be able to function as a society to resolve our differences in hopefully productive and well-reasoned ways. So I've been asked to talk about specifically the history of courts and redistricting in Wisconsin, and I do think that this, as you're going to see toward the end, gets to issues of fairness and impartiality. I will say that right now, in addition to the previous redistricting cycle in 2011, when I tried cases in Kenosha County, and then the overall state Wisconsin redistricting case in the federal court, and then the partisan gerrymandering challenge in the Whitford versus Gill case. I'm right now involved as lead trial counsel in two different redistricting cases that we have going. One is in the federal courts in Madison, and then one is currently before the Wisconsin Supreme Court. So this is a topic that's near and dear to my heart and to the work that I've been doing. So let's start out at probably the most pertinent time for purposes of this discussion, and that's in the 1960s. We've had, in Wisconsin, we actually call what we all refer to colloquially as redistricting, and know it as that, is actually called the Wisconsin Constitution apportionment. That's what the title of the statute is. It's called apportionment. And so it's been in our Constitution since the 19th century, for a very long time. But really the time frame that we need to start thinking about or start from is the 1960s. It's a time of what we call the Redistricting Revolution that happened in the 1960s. And it was because of a series of opinions issued by the United States Supreme Court, starting out with Baker versus Carr in 1962, where the United States Supreme Court interpreted the Equal Protection Clause of the 14th Amendment to require equal population among districts. And this had to do with vote dilution and the power of a vote. So if you've got districts that are heavily populated and districts that have fewer people, one of the ways that you can dilute a vote is to put a lot of people into a single district. And if you've got districts, if you've got 99 assembly districts like we have in the state, and if you have, like, let's go to extremes and say, you've got one person in 98 of those districts, and you pack everybody else into that 99th district, you can see how your vote would be diluted. And so the United States Supreme Court held that we have to have population equality among districts. And that in a series of different opinions in the 1960s by the US Supreme Court, they applied that one person, one vote principle to state legislative districts, congressional districts, local districts like county supervisory districts, aldermanic districts, those kinds of things. So we now have population equality. That is required by the US Constitution. It can vary a little bit. Congressional districts, we require perfect population equality. So in each of Wisconsin's 8 congressional districts, they all have to be the same size population-wise down to the individual person. In state legislative districts and then local districts, variation can be up to 10% from the lowest populated to the highest population. But they generally have to have the same equal population. Well, that's important because our population changes over time, changes constantly, right? People move into districts, they move out of districts, people are born, people die. But we have this thing every 10 years called the census, as we know, because it was just taken last year. So it was taken in 2020, it was taken in 2010, and then decennially in the decades before that. And so what we do in terms of the law is we have this redistricting or apportionment that happens in the year after the census is taken, and it happens every decade. And so that's become important since the 1960s. And so really, that's the place where we want to start the redistricting discussion for our purposes. Now, in the 1960s, there was another very important case that was decided in Wisconsin, and it was called State ex rel Reynolds versus Zimmerman, decided in 1964. And that case is important because in that year, or in that apportionment cycle, the Wisconsin state legislature attempted to apportion new state legislative districts using what is called a joint resolution in Wisconsin. Those of you who have paid a lot of attention in the past year to redistricting here will understand, you'll know what a joint resolution is. But it can be contrasted with a statute. So a statute in Wisconsin has to be passed by both houses of our legislature, our assembly and our Senate. And then there is something called the presentment clause in the Wisconsin Constitution. And that means any bills that are going to be passed into law have to be presented to the governor for the governor's signature or the governor's veto. That's the presentment clause. So legislation, the way legislation is adopted, it passes the legislature and then it gets presented to the governor. If the governor signs it, it's enacted into law. That's legislation. A joint resolution is different. A joint resolution is simply a resolution that's passed jointly by the two houses of the legislature. So it's not subject to the governor's veto. Now that was important in 1964 because, as we all know, redistricting or apportionment is an inherently political activity, right? We know that. And so if you've got one party that controls the legislature and the governor is of a different party, obviously the legislature wants to try to avoid that gubernatorial veto if they can. So in the 1960s, that's exactly what the legislature tried to do. They tried to redistrict and adopt newly apportioned districts through the use of a joint resolution that wouldn't be subject to the governor's veto. And the Wisconsin State Supreme Court said that dog don't hunt, right? That won't fly. You can't do that. That's contrary to Wisconsin law. And we're going to hold that's invalid, that any redistricting, any apportionment that comes out of the legislature has to be subjected to the governor for signature or veto. It has to be done by legislation. So that's another foundational case that we need to keep in mind. So the 1970s, the first apportionment cycle after we'd had these one person, one vote cases, we don't get to test the legal theories because lo and behold, there's an enacted plan and there's no challenge to it. So it actually, the legislature passes, adopts new districts, the governor signs them into law, there's no court involvement, so we don't have a challenge. The 1980s, first time we now have a challenge with this new one person, one vote framework in place. And there in 1981, the legislature passed an apportionment plan. Governor Dreyfus at the time vetoed it. So we had what we call an impasse, right? IMPASSE. We have disagreement between the legislature and the governor. So we have a districting plan that can't go into effect. And we're stuck with that plan from the 1970s. Now we go back, remember, to the Supreme Court cases, one person, one vote cases from the 1960s, and they say, well, you can't have malapportioned districts. So we have districts that were adopted in the 1970s, but now it's 1981. And we know a lot of people have moved into districts and moved out of districts. So we have a lot of malapportionment, right? We have a lot of variation in the populations among the districts. And so those districts are unconstitutional. They can't stand. But the governor has vetoed the apportionment plan that the legislature passed. So what to do? Well, what happens then is that courts step in. And now courts are going to decide what the new districts should be. And this was done in the federal court in 1982. And so this is in what we call the Eastern District, the United States District Court for the Eastern District of Wisconsin. That's a federal court in Milwaukee. We have two different districts in Wisconsin, the Eastern District and the Western District, the two federal court districts. The Eastern District is in Milwaukee. The Western District is in Madison. So this is a panel of 3 federal court judges. In these cases, unlike most other cases where you just have one judge, these cases actually have 3 judges who sit. And so they're appointed by the chief judge from the 7th Circuit Court of Appeals. That's the Court of Appeals that sits in Chicago, and it has charge over the federal courts in Illinois, Wisconsin, and Indiana. So the chief judge, these cases get filed. The chief judge for the 7th Circuit appoints a panel of 3 judges, and those 3 judges hear the case. Interestingly enough, just point of trivia here, but those cases, when they decide them, then they go immediately to the United States Supreme Court. There's no intermediate court of appeals, and it's a mandatory appeal. It means the United States Supreme Court must take them. Most other cases, they get to decide what they take, but these cases they have to take. So 1981, we don't have an enacted plan, so it falls to a court to make the decision. It's a 3-judge district court panel in Milwaukee that decides the case, and they come up with new districts. And those districts then become the law for Wisconsin. And those are the state legislative districts and the congressional districts that are in place throughout the 1980s. So now we come to the next decade, 1990, a new census is taken. 1991, it's a new opportunity to newly apportion. So what happens? Well, the legislature again passed the apportionment plan, but again, we have a Democratic controlled legislature and a Republican governor, Governor Thompson at the time. Legislature passes a new apportionment plan, Governor Thompson vetoes it. Same thing happens, right? We have an impasse, and so a court has to step in. It's still a federal court. This time, though, it's the federal court in Madison. So it's a 3-judge panel in Madison that's deciding what the new districts should look like. And that 3-judge panel in Madison decided that case. They adopted new districts in the 1990s. Let's go to the 2000s. What happens? 2000, another census is taken. 2001, another opportunity for new districts to be adopted. So now we've got a legislature that's split between the parties. I think it's the Democrats control the Senate, and I think that the Republicans control the Assembly. So now we can't even have legislation that will pass the legislature, no opportunity at all for the governor to either veto it or sign it. So there's an impasse at the legislature. So in a case called Baumgart versus Wendelberger, and we're back in Milwaukee now in 2002, that there's a 3-judge federal court that adopted a new apportionment plan because the political actors couldn't agree. So now you see here we've got both in 1982, I should say not both, but in 1982, 1992, and 2002, we have the federal courts that are all deciding these issues. Now, there was another case that was filed also in the early 2000s that related to redistricting. And this one, as you can see, I've got it up on the screen in front of me. This one was actually filed in the state court. This is the Jensen versus the Wisconsin Elections Board case. This is filed in state court. And there is a state legislator, Scott Jensen, a Republican, who filed a challenge to relating to redistricting. And he filed it and wanted the state Supreme Court to take it up. So he didn't want this to be decided in the federal court. He wanted it to be decided in the state Supreme Court. So he filed this action. And the state Supreme Court, he filed it as what's called an original action, meaning he didn't file it in a circuit court like Dane County or Milwaukee County or Waukesha County. It was an original action filed in the Wisconsin Supreme Court. And when you file something as an original action, you're asking the court, the state Supreme Court, to take it as an original action. It's discretionary on their part. And the state Supreme Court in 2002 said, we are not going to take this case because it's already pending in the federal court. And the federal court's going to decide it, so we don't need to. So we're not going to decide it. But what we are going to do, the court decided, is that they decided to initiate a rulemaking process. This is the state Supreme Court doing it on its own. And they said, we will initiate a rulemaking process to decide whether we should establish a rule where apportionment, redistricting, or apportionment litigation will be decided by the Wisconsin State Supreme Court. And they appointed a panel of experts, and these were mostly subject matter experts, not lawyers, not judges. There were some judges, but mostly lawyers. Mostly subject matter experts. And they spent about 7 years coming up with a proposed rule. And that rulemaking procedure culminated in a number of hearings in 2009. And in 2009, the Wisconsin State Supreme Court held a number of open sessions. These were all videotaped and they're available. You can get them. We've got copies of these if anybody wants to watch them. But after 7 years of study, the court held hearings or held a conference among the members of the court. And what the members of the court decided is that in part and significantly that apportionment cases, redistricting cases, are simply too political. They shouldn't be in front of the state Supreme Court because state Supreme Court justices are elected. And it would inject too much in the way of politics into supposedly nonpartisan Supreme Court elections. And this was a view, we've got it on video, that Justice Prosser, who was on the court at the time, Justice Prosser had that opinion. Justice Rogensack, who was on the court then and is still on the court now, said the same thing. And Justice Ziegler, who was on the court then and is now the Chief Justice of the Wisconsin Supreme Court, said the same thing. Even Justice Gableman, who was on the court at the time, said the same thing. So these justices all said, this is way too political, too much of a hot potato. The public is going to lose confidence in the courts as putting their thumb on the partisan scale if we take these cases. So we don't want to take these cases. And so they denied this rulemaking petition, said they weren't going to come up with a rule. All right, we'll come back to that in just a minute. So now let's go to the 2010s. And in 2010, as people remember, in the midterm elections, Republicans swept all of the races in Wisconsin. They won the legislature, so they won the state Senate, they won the state assembly, and they won the office of the governor as well. So you had unified Republican government. And so for the first time in a very long time, since the 1970s, you actually had an enacted plan. 2011 Wisconsin Act 43. Those are the state legislative districts. They were passed by statute by the legislature, and they were signed into law by Governor Walker. They were then challenged in federal court. This is a case that I had filed in the federal court in the Eastern District of Milwaukee, Wisconsin, so in Milwaukee. And we litigated them through. We had a trial in February 2012. And as a result of that trial, the court held that Assembly Districts 8 and 9 in Milwaukee violated Section 2 of the Voting Rights Act, violated the rights of Latino voters in those districts. And so the court asked for new districts to be proposed. We proposed new districts and the court adopted those. Otherwise, the districts as adopted by the legislature and signed into law by Governor Walker remained in place and remain in place to this day. Now, the other important thing that happened in 2011 is that there was another case that was filed at the time. There were actually two other cases. One was filed in the Wisconsin Supreme Court. It was another original action, again, asking the state Supreme Court to take as an original action the redistricting dispute. And the state Supreme Court, interestingly enough, just sort of sat on it. They didn't decide it. They didn't ask for more briefing. They just sat on it. And then a couple of years later, they decided to just dismiss it because the federal case had already gone through to finality and been decided. So they didn't rule immediately. They just sat on it and then ultimately dismissed it. The other thing, though, that happened in 2010 is that there was a lawsuit in Waukesha County Circuit Court that attempted to take advantage of a new statute passed by the legislature in 2011 that said if there is a redistricting challenge, a challenge to the apportionment of districts, that it could be filed, a plaintiff could file a lawsuit in any circuit court in the state, and that the Wisconsin State Supreme Court would appoint a panel of 3 circuit court judges to hear the case. So interestingly enough, that statute was passed in 2011, but then it wasn't actually given effect and followed in the same cycle. There was another significant case during the 2010 apportionment or redistricting cycle, and that was the Whitford versus Gill case that I referred to before. So that was a case where we filed a lawsuit in the federal court in Madison, challenging that same statute, 2011 Wisconsin Act 43, as an unconstitutional partisan gerrymander. That was heard by a 3-judge federal panel in Madison. We won that case after a trial, but when it went up to the United States Supreme Court, the Supreme Court reversed. They vacated the judgment, not because they thought that the district court got it wrong in terms of the merits of the case, but they said that we didn't prove a requirement called standing. We didn't show actual injury to each and every plaintiff who brought the case. So they took away our win, essentially, and they sent us back down for a new trial. Before we got a chance to have that new trial, though, the U.S. Supreme Court decided in another case called Rucho versus Common Cause out of North Carolina that federal courts actually don't have jurisdiction to be able to hear claims for partisan gerrymandering. And so the Whitford case was dismissed. So that brings us up to today, 2020s. That's where we are now. The census was taken last year. And so we would expect that we would have new districts, right? That they would be adopted. So what's happened so far this year? Well, there was a rulemaking petition that was filed in June of 2020 by the Wisconsin Institute of Law and Liberty. And they asked the state Supreme Court to adopt a rule that would govern redistricting challenges or apportionment challenges. That was actually rejected in May of this year. The state Supreme Court said that it wasn't going to adopt a new rule like they did back in 2019. Consequently, when the new data was released by the Census Bureau, and that was just done in August this year, it was late, there were two challenges that were filed in federal court in Madison, one called Hunter versus Bostelman, and then one that I'm involved with, Black Leaders Organizing for Communities. And by the way, the League of Women Voters of Wisconsin is a plaintiff in that Block versus Spindell case, where I am representing the League of Women Voters of Wisconsin. We filed that on August 23rd. So we filed in the federal court just as it had been done last decade, the decade before, the decade before, the decade before. But in addition, this year, there was a wrinkle. There was a new case that was filed as an original action in the Wisconsin State Supreme Court called Johnson versus the Wisconsin Elections Commission. That was filed by the Wisconsin Institute for Law and Liberty, and they asked the state Supreme Court to take original jurisdiction over the state redistricting dispute. And on September 22nd, so not very long ago, the state Supreme Court did that. They took original action jurisdiction. So right now, this battle is being waged on two fronts. We have a case that's going forward in the Wisconsin State Supreme Court, and a case also that is pending in front of the federal court, a three-judge panel in the federal court in Madison. And so I will pause it there, and I will stop sharing my screen.
All right. Doug, I wanted to let you bring your plot thread right up to the present without interruption, but we want to speed on now to Doug Keith.
Great.
And Doug, you're going to tell us about what we should all expect from our courts and what we are not always getting. So I'll let you speak and share the screen as you need.
That's great. A helpful segue. Thank you. I won't be sharing the screen. I unfortunately don't have slides tonight, so you'll have to look at me while I'm chatting. But Dorothy is right. I want to talk a little bit about what we are supposed to expect out of courts. I'm a counsel on the Brennan Center's Fair Courts team. What do we mean when we talk about fair courts? This idea of fairness can mean different things to different people. Maybe you're looking at the quality of the judge's decision or transparency. You want to know more about how the court reached this decision. But there are two values that I really want to talk about that are generally agreed upon as essential to the role of courts in our democratic system. And there are things that have been already mentioned tonight, and that's independence and impartiality. And so what do we mean by those two things? Independence is this idea that judges should be able to make decisions without regard to loyalty to another branch of government or another entity, whether that's a political party that they're a part of, a major donor, or some other financially interested party in a court's decision. For example, if the legislature is defending a law in front of the court should be able to decide cases about the legislature without regard to what the legislature wants. It is not the court's job to look out for the legislature's interests. And then the second concept is impartiality, which reflects this idea that even if the judge is independent, the judge is going to bring their own personal biases or preferences to the bench with them. Judges are people just like all of us. And so it's not reasonable to expect they won't have biases, but it's reasonable to expect that those biases do not inform their decisions and should not get in the way of their decisions. So why do these concepts matter? Why do we need a judiciary that's independent and impartial? And the key thing to understand here is that in our three-branch system of government, courts have almost no power, or at least significantly less power than the other branches. And I'll say more about that. I'll talk more about a Supreme Court decision, a recent Supreme Court decision that's very important called Williams v. Lee v. Florida Bar. And here I want to quote a little bit from that case. The court's opinion, it said that the importance of public confidence in the integrity of judges, it stems from the place of the judiciary in our government. Unlike the executive, the governor, the president, unlike the legislature, the judiciary has no influence over either the sword or the purse. They don't control law enforcement. They don't control state funds. The judiciary's authority depends on the public's willingness to respect and to follow its decisions. There's a famous U.S. Supreme Court Justice Frankfurter, who once put it for the court, and the court likes to quote this over and over again: justice has to satisfy the appearance of justice for the court decisions to get respect from the public. And with sort of this thinking in mind, we should also be aware that public confidence in the courts is waning. All you have to do is look at recent polls to see that this is happening. A 2021 Gallup poll that just came out found that 54% of Americans have a fair amount of trust in the judiciary. For the last 25 years, the average percentage for the same question has been 68%. So you've seen a dramatic decline, and a decline that we should probably expect is going to continue unless something changes. At the state level, a survey found an 11% decline from recent years in terms of how much confidence the public has in courts. And that same survey found that less than half of respondents agreed that state courts were unbiased. So more than half of respondents thought that they were biased. And so if courts are going to be a meaningful check on the other branches, which is what one of their primary responsibilities in our system of checks and balances, it's essential that we come up with ways to inspire confidence in their decision so that the public actually sees a reason that they or their leaders should follow them. And the way some courts are behaving in this moment, and the way the other branches of government are interacting with courts does not inspire that confidence. So I mentioned a Supreme Court case that I want to talk a little bit more about, and that's the Williams v. Lee, the Florida bar decision. And this was a Supreme Court decision, a Supreme Court case involving a challenge to a judicial ethics rule from Florida. And specifically, the rule prohibited judges from personally soliciting or accepting campaign contributions. You know, if they're running for office, they have a campaign account that can raise money, but the judge can't take that money themselves. They can't ask for it themselves. And the idea here is that proximity between the judge and the donor creates too much of an appearance of impropriety, of a potential conflict of interest. And so many states have implemented a rule like this. In fact, of the 39 states that use elections to select at least some of their judges, 30 of those states have a prohibition, just like Florida did, and Wisconsin, in fact, has this rule. So an attorney in Florida challenged this rule, saying, an attorney who was running for judicial office, saying, this actually violates my First Amendment rights. I want to be able to ask for contributions in the way that any other political candidate can ask for contributions. And so that attorney lost at the US Supreme Court. And there are sort of two big takeaways from this case that I think are important. One, the US Supreme Court recognized that states have an extremely important interest in maintaining judicial independence, and not just maintaining actual judicial independence, but ensuring the appearance of judicial independence for the public's benefit. And second, the court recognized that because this interest is so important with regards to the judiciary, and because it's unique with regards to the judiciary, you know, that same interest doesn't really exist when it comes to legislators or when it comes to the governor. The court recognized that states may have some additional leeway for regulating judges that they just don't have in terms of regulating other political officials. And so we should really think of Williams v. Lee as opening the door to reform, especially in light of some earlier US Supreme Court decisions, which had struck down common judicial ethics provisions on First Amendment grounds. What Williams v. Lee did was it sort of reset any assessment of judicial codes of conduct and allows us as reformers to think, okay, we may be able to do things here that we can't do in other political contexts in order to rein in sort of the worst aspects of of the conflicts of interest that are present in this branch. And so along those lines, the last thing I want to talk about is recusal rules. And so in terms of maintaining impartiality and independence and the appearance of those things, one of the most important rules to have in mind are rules related to recusal. And those are the rules for when a judge needs to step aside from a case because they have a conflict of interest, or because there's an appearance of a conflict of interest, because the public might reasonably think that they have a conflict. And when you think about recusal rules, sort of what these rules should be, you want to break it down into two parts. There's what I'll call the substantive portion. When do the judges have to step aside? Sort of what are the circumstances in which recusal is necessary? And then procedural, sort of who decides this? Who should be the one ultimately making the decision whether the judge has to step aside? And states have a lot of work to do on both fronts. On the substantive, the rules that exist across the country and in Wisconsin in particular, maybe especially, just don't reflect the reality of judicial elections today. Most states' judicial codes of conduct, the rules for when judges have to step aside, do not provide a threshold at which campaign contributions create a conflict of interest requiring recusal. And some states like Wisconsin actually go so far as to say that campaign contributions cannot create a conflict of interest requiring recusal. But with the reality of how judicial elections are functioning across the country today, these campaign contributions there needs to be an objective standard by which political donations trigger a requirement for recusal on high courts, at least across the country. And if you're concerned about public confidence, again, it's worth looking at the polls here. We did a poll somewhat recently of the public to just get their assessment of campaign contributions to judges, and 90% of public respondents said that they thought campaign contributions affected judges' decisions. So if you are concerned about public confidence, you have to be concerned about these contributions. An interesting takeaway from this poll, 50% of judges themselves thought that campaign contributions affected their colleagues' decisions. So even the judges are concerned. But in the Wisconsin rules of judicial conduct, the comment to that rule I mentioned, sort of prohibiting campaign contributions from triggering recusal, the court said that recusal based on campaign support would, quote, deprive citizens who lawfully contribute to judicial campaigns of the access to the judges that they helped elect. Now, I think all of us on this call understand that no donor is entitled to access to the judge that they've given a contribution to. And that is no reason to allow for conflicts of interest to run rampant across the state. So now moving beyond the substantive, I want to talk a little bit about the procedural. Again, who should be making this decision? And ultimately what we've learned across the country, and it's sort of a general understanding, especially over the last decade or so, is that there needs to be independent review of any requests for a judge to step aside. That is, the judge who is asked to step aside, the judge who is told you might have a conflict in this case, cannot be the one making the final decision as to whether a conflict is present. And unfortunately, in most states, especially at the high court level, at the state Supreme Court level, it is up to that judge who is being challenged, who's being asked to step aside. That judge gets to make the final decision. That said, 15 states require independent review. That is, if there's a recusal motion, either the rest of the court gets to decide, or the court with that judge's involvement gets to decide the recusal motion. So that it's not just the challenged judge who's assessing his own bias. There's tons of social science research showing judges, like all other people, are pretty bad at assessing their own bias. We all think we're better at identifying bias in ourselves than everyone else is. And so there's no reason to trust judges here, just as we wouldn't trust other people. I want to wrap up quickly because I know we have a lot to talk about, but I just want to flag, and I think Debra will speak to this, if you're looking for a model on recusal rules, you really don't have to look further than the proposal put forth in Wisconsin in 2017 by so many of your former judges. That proposal, which was submitted in a petition to the Supreme Court, included all of these essential elements that I'm speaking to: independent review, rules that require recusal based on campaign contributions, rules that consider independent expenditures to be a form of campaign contribution because those expenditures are so essential to how judicial elections function today. So I really would hold that up as a model for the rest of the country to follow, even if the court in Wisconsin didn't believe it themselves. But I'll stop there, and I'm happy to answer questions once we're all done.
Okay, thanks, Doug. Certainly recusal procedures are key to increasing the public confidence in our judiciary. Thanks, Doug. Finally, let's hear from Debra Cronmiller to help us understand what the League of Women Voters has been doing to help ensure a fair and impartial judicial system. Debra?
Thank you, Dorothy, and thanks to all of you for participating tonight. This is an exciting kickoff to a bigger discussion that the League is starting to create in the state of Wisconsin. Since 2018, the State League has been partnering with the Piper Fund to actively lead this conversation. We've been engaged in national conversations with other leaders in this space, and we're talking on a monthly basis so I can learn, and our small committee here in Wisconsin can learn from one another. And so we have a chance to maximize our chance for real change in Wisconsin. We've participated already in different focus groups to help us learn how best to message around fair courts, impartial justice, what are the right words, what resonates with the most people. And we've identified a number of goals that we want to be working on in the immediate future to really affect change in this fair court space. One of our big goals is to connect issues that we're wrestling with here in the state of Wisconsin with fair courts. And so people understand the importance of courts in those issues that are impacting our lives every day. And the issues I'm talking about are fair maps and the role of courts, what as Doug was explaining, what the role of the court has been in creating the redistricting process, rights restoration for felons, jail voting rights. As Keith was just speaking about, we need to talk more and continue the conversation on recusal and ethics in promoting the recommendations that we know to be good best practices in the nation from our experts like at the Brennan Center, but also from our own research. The League this year did a white paper on business courts in Wisconsin, and we need to get the content of these documents and these discussions to more ears and eyes in the state of Wisconsin. Of course, we want to keep a high-level conversation constantly going about the need for judicial independence and accountability. We want to begin a conversation in Wisconsin about systemic racism in Wisconsin's judiciary. We want to support you, our local league members, as you're trying to have local conversations about the importance of judicial independence. We want to help give you tools and resources, including resources in multiple languages, so that this information is accessible to everyone. We want to create online and digital strategies across multiple platforms that will help inform and increase awareness and encourage public engagement in all of these issues. And we want to initiate more research to determine the best practices in educating the public, not only about the issues I've already mentioned, but here in Wisconsin, we have a Judicial Review Commission. More people need to know about the work of this commission. We need to hold this commission accountable to do its job to review judges and their decisions, and when appropriate, to discipline or disbar. In addition to these things, we're going to continue to do what's the core of our work, which is we've got to make sure every person who votes in Wisconsin understands what our judges stand for, what their records are. So we're going to continue to produce and distribute Vote 411, the voting guide. We started a couple of years ago creating distributing guides, 101 guides, if you will, on what the different courts and what the different judges in those courts do and what they're responsible to do. We call these the 101s, and we want to get these out to more people in Wisconsin. We want to create and distribute more bilingual information, as I indicated. We want to sponsor the 2022 civics games in our high schools. We want to create and distribute information about the role of state and federal courts, not only in drawing district maps in Wisconsin, but in the importance that they have in many different cases that impact our lives, that we know so many Wisconsinites favor, but aren't necessarily coming out of our legislature. I think that it's really important that we as an organization elevate the importance of lower courts in the minds of all of our voters. 95% of all judicial cases are decided in lower courts. These are the decisions that impact our families, our communities, our businesses, and yet we, the general public, don't always understand what's happening in these lower courts, how important they are, that they are the learning ground or the testing ground for the judges that will become the judges that sit on our higher courts. And we need to get this kind of information out and these kind of discussions happening throughout Wisconsin. Finally, I think we need to jumpstart a conversation about money in the judiciary. As Doug Keith was just mentioning, money can taint a judge. Money has likely tainted many judges in Wisconsin. Money gives influence to corporations and influence to political parties that can't help but pressure a judge to weigh in a certain decision. And I think we need to have a very frank conversation about the appropriateness of money not only raised by candidates for their own judicial elections, but the money that pours into the state from other states and PACs and whatnot to support and or oppose judges in local races and mid-level races, and of course in our Supreme Court races here in Wisconsin. You know, we've seen hundreds of thousands of dollars last April flow into lower court judicial races. This is new to us in Wisconsin. We saw millions of dollars come in from out of state for our Supreme Court race in 2020. We're anticipating in 2023 to see even more. We need to start now the discussion about what do we as citizens do when we know this is happening. And we hope that all of you will be an important part of this upcoming conversation and continued strive for education. Thank you.
And thank you, Deborah. I can tell from the gist of the comments and questions in the chat that most folks have been thinking that the only thing that we need to worry about with regard to the courts and the judiciary is their role in redistricting, right? But in fact, I hope that we have maybe expanded your appreciation of all that needs to be addressed to ensure an impartial judiciary and to justify why we want to turn this into a series of webinars to discuss the various aspects. But because redistricting is the hot button issue right now, I'm going to concentrate on that in the Q&A session here. And so starting here, Vicky says, will there be a precedence that applies to the original jurisdiction reapportionment cases in the Wisconsin Supreme Court? In other words, how is all this jurisdictional stuff going to boil down and influencing our redistricting maps. And Doug, why don't you start with Doug Poland? Why don't you start on that? And then Doug Keith, you can chime in.
Are you done? Still an open question right now. If the courts follow the precedent that's been set in the past, then the Wisconsin State Supreme Court will take an initial shot at coming up with the districts. Now, there are federal claims that are involved. There are constitutional claims. There's the Voting Rights Act. And so the position that we have taken on behalf of the league and other plaintiffs is that once the Wisconsin State Supreme Court comes up with what it believes the districts should be, those are still subject to review by the federal court that we already have an action pending in front of in the Western District of Wisconsin, so the federal court in Madison. That's our view. That is not the view of the lawyers who are representing the legislature and who are representing the Wisconsin Institute for Law and Liberty. They have a different view of it. So this is still a little bit of an open question. But if the court follows precedent, then we should have the federal court in Madison should have the last say. Of course, the United States Supreme Court ultimately would have the last say in either event, but it really should be heard by the federal court in Madison.
Let's see here. Relative to that, all these questions are closely related. What happens if the state Supreme Court and the federal court both take on the redistricting task?
Well, there's very well-respected precedent on that. There are principles of federalism that come into play. And so the federal court has already said that it is going to wait. It has stayed our case in the federal court in Madison, and it's going to wait for the Wisconsin State Supreme Court to do its thing. It doesn't have to wait forever, and it won't. And they've set a trial date, or they've reserved time beginning the week of January 31st to have a trial in the federal court as to whether whatever the districts are that the state Supreme Court comes up with, if those comply with the federal Constitution and with the Voting Rights Act. So what we have urged the state Supreme Court to do is to hold whatever it's going to do, it needs to do it by the end of January so that we can get in front of the federal court by January 31st.
All right, and I don't want to neglect the first question that came up in the chat, and this is a question that often comes up in localities. There have been questions about the order of drawing maps. Is it true that it used to be municipalities drew maps first, then counties, and then the state? Has that changed? What's going on there?
Yeah, it has. I referred to that earlier. This is this 2011 Wisconsin Act 39. And so, excuse me just a second, I've got a very needy border terrier here who's decided it's time to sit on my lap. Apologize. It's very difficult to draw a gerrymander if you are the state legislature, if you are inheriting the building blocks for your districts from what the municipalities decide they're going to draw the wards. So before 2011, municipalities drew wards, then counties drew supervisory districts, then the wards were given to the state legislature and it would draw districts. In 2011, the Wisconsin legislature changed the order. It decided that what would happen is rather than wards being drawn by municipalities, and those would be the building blocks, that there are these things called census blocks that are determined by the US Census Bureau. And those are released when the Census Bureau releases the redistricting data, the apportionment data, typically at the end of March. It would have been 2011. And so they passed that statute, 2011 Wisconsin Act 39, and that did two things. Number one, it said that any of the wards have to be based on or encompass whole census blocks, okay? And then the other thing that it did is that it said that if any wards conflicted with state legislative district boundaries, that the municipalities had to change their wards to conform to the state legislative district boundaries. And so it really made, it flipped the order, and it made it easy for the state legislature to draw state legislative districts right off the bat as soon as the data were released.
And when the when the courts redraw the district maps, how do they do that?
Well, they really have. The way they've done it historically in Wisconsin is they've asked the parties for their suggestions. So they've asked for proposed maps. And that's the way that it's been done. That's the way that we're proposing it be done again this year. Some other places it's been done differently. Sometimes they will appoint subject matter experts as what we call special masters. And so these are people who are very well steeped in redistricting. They know how to do it. They're impartial. Many times they're professors, law professors or political science professors, and they'll assist the court in drawing those districts. But that's never been done in Wisconsin before, and we're not. What we're urging the Supreme Court to do this time around is to select from the proposed districts that are supplied by the parties. And
here for a wrap-up question, this is the tough one that always comes down to the bottom line from an impatient, reasonably an expected to be impatient listener who says, can we get to the bottom line? Regarding fair redistricting, the legislature proposal will be vetoed by the governor and the issue will go to the courts. So what can we do? Is this a legal issue that citizens can act on?
It is a legal issue, but it is also an issue for the grassroots community as well. And Debra can speak to the Fair Maps and what the Fair Maps Coalition is doing. You know, we are doing what we can in court, and you can certainly contribute to that by supporting the league. You know, the league is a client of ours, and we're representing them. You know, really in terms of what you can do as ordinary citizens, you can participate in the Fair Maps initiative and the coalition, the work that it does. But remember, and this gets to an issue that Doug Keith was talking about, you know, this is judicial accountability, and this is a question of judicial ethics. And we have we're supposed to have nonpartisan judges in Wisconsin. If you believe that judges are not acting in a nonpartisan way, if you believe that they are acting as partisans to actively support and help out partisan political actors, we elect our judges and they serve for terms of 10 years. The next election, as Debra said, is in the spring of 2023. There will be Justice Pat Rogensack will be retiring. Her seat will be up for election. And if you feel strongly about who should be in that seat, then that is an election that you want to focus your efforts on.
All right. Well, thank you, audience members, for joining us this evening and for your interest in fair and impartial courts in Wisconsin. As we said, tonight's discussion is just the first of a number of upcoming webinars that will delve more deeply into recusal, money in judicial races, equity in sentencing, and other issues facing the Wisconsin courts. Thanks to tonight's excellent speakers, Doug Poland, Douglas Keith, and Debra Cronmiller. Good night, be well, and we'll look forward to seeing you in the continuation of this conversation, everybody.
Thank you.